I am.
All right, proceed.
Thank you. Good morning. May it please the court. My name is Stacy Blank. I'm here today on behalf of the appellant MHC Holdings. I'd like to reserve 5 minutes of my time for rebuttal.
You got it.
Thank you. This case is part 2 of the court's arbitration theme for today. In this case, the trial court confused the threshold question of whether the parties formed an agreement to arbitrate with the separate question of arbitrability. That is, whether the particular dispute falls within the scope of any agreement to arbitrate. Florida law uniformly holds that the courts and not the arbitrators must make the threshold determination of whether there is an agreement to arbitrate between the parties. Here, MHC challenged the existence of an agreement to arbitrate, and once MHC raised
well, actually, let's talk about how this actually materialized. MHC, the plaintiff, the physician partners initiates its arbitration on May 12th, pursuant to the contract by filing a petition with ALA, the American Health Lawyers Association. That happens on May 12th, and they send copies to Mr. Kohler via mail and email. Within some days, Kohler signs into the ALA system where the rules say once you do that, you're presumptively on notice of everything that happens. Then on May 18th, he files a declaratory action challenging the arbitrability of this thing in Volusia County. But he doesn't bring that to the attention of the arbitrator who, and then he dissolves the corporation on May 19th, or he tries to. And then the arbitrator holds this hearing on May 23rd, and we've seen the arbitrator's order that has a half-page footnote detailing what he went through to try to get Kohler to respond. And so at the end of the day, what happens is he enters, Kohler he doesn't show up. He enters this award. He has a follow-on award, another award that he enters in July. 93 days later, your client filed, 93 days from the original award that your client is challenging, your client responds to the motion to confirm the award by moving to vacate. And that's really what we're looking at, isn't it? The motion to vacate the arbitral award, because your whole shooting match hinges on the arguments you made to vacate the award, doesn't it?
No, it doesn't.
Why not?
Because the burden is on the party seeking to compel arbitration to establish.
But we weren't on a motion to compel arbitration.
But we should.
This was a motion to confirm and a counter motion to vacate.
But that's the point, is we should have been here on, because it is a threshold.
Well, the way your client could have gotten there was to bring the declaratory action that he filed before the arbitration hearing to the arbitrator and say, I'm challenging this. A judge must decide arbitrability, and I need a stay. But he didn't do that, and we know that he was on notice.
But I think even the appellee here would concede that MHC had no obligation to participate in the arbitration. I mean, it just didn't. If it
Why would they? Given, I don't think that's their, have you read their brief? I don't think that's their position at all.
Actually, they did. They said that in essence, that if what the court had said is that you must participate in the arbitration as a condition of asserting your objection to the existence of the agreement, that would be erroneous. But what you did is you participated in the arbitration without objecting to it pressing forward.
Well, then we can focus on the definition of participation, because
Correct.
I think you have to concede that your client, your predecessor counsel, who I know isn't one of your law partners or anything like that, but the way that the run up to the arbitration hearing and the filing of the motion to vacate, you know, I think your opponent's position is pretty clear. MHC was bound by virtue of the transactional history involving the assignments and so forth. He gets notice of the initiation of this arbitration pursuant to the rules that the contract, which MHC took an assignment of, says. And then he, you know, it's like the hokey pokey. He's got 1 foot in and 1 foot out. And now that he doesn't like the end of it, he's wanting to vacate the award. But I think that under your construct that you just articulated, the question becomes, did MHC participate in the arbitration?
Clearly they didn't, and we know that. I mean, the
Well,
trial court said
I
it.
don't agree with you on that. You're gonna have to sell me that he was served,
Okay,
his client
so
had accepted an assignment of this agreement, he was served in accordance with the procedures specified therein. He logged into the ALA website, which had rules that say, once you do this, you're on notice, you're part of it, you're participating. And at the same time, he's challenging the arbitration in a separate filing in Volusia County that nobody later.
So let's take each one of those point by point. So the waiver statute says that you have up until the commencement of the arbitration hearing to assert an objection before you have been deemed to participate without objection. And so the fact that he, I'll talk about the AHLA.
When you say the waiver statute, are you referring to subsection
682.13?
682.13E? Okay.
Correct. Yes.
Which says there was, on motion of party, the court shall vacate if there was no agreement to arbitrate, which is your position, unless the person participated in the arbitration proceeding without raising an objection, not later than the beginning of the arbitration hearing. And given the footnote in the arbitrator's order, the arbitrator certainly believed and took the position that Mr. Kohler was participating.
But he never
That's why
did.
he went.
So let's look at what he actually did. I mean, so the way this AHLA thing works is when the party seeking to arbitrate files their demand, they can provide an email address to the AHLA administrator. That person then sends an invitation that says, here's something's, going on.
Create an account. Create an account, log in, create an account.
It's an invitation. So he clicks on it, that automatically, registers him. He has access to it. And based on nothing more than that, he is deemed to have participated in the arbitration. Notwithstanding that the very next day he sends a letter saying, wait, whoa, I'm not the lawyer on the arbitration.
Well, but at the same time, while he wasn't the lawyer on the arbitration, he's filing a deck action challenging the arbitrability of it and dissolving the company.
I understand that, I don't think, I filed a lot of lawsuits in my day, but I'm not sure I would be qualified to be an AHLA arbitration lawyer. So there is a differential there. And I don't think it's inconsistent for him to say, I accepted this, baiting email that was sent to me because I'm not sure I knew what it was. But that doesn't mean he participated in the arbitration. They didn't attend one hearing. And, let's look at the court's order. In the order confirming, the trial court expressly found that MHC did not participate in the arbitration. For example, on page 7 of the order, that's in the appendix at 546, the trial court stated, MHC had the opportunity to participate in the arbitration, but strategically decided not to.
And tell me how that is.
548.
Excuse me. Let's stop right there. Okay. Tell me what is wrong about the finding that you just recited that the trial court made.
I don't think there is anything wrong. They did not participate.
But
that's my point, is that they did not participate in the arbitration, and so there was no waiver of this agreement.
Well, I think that you're going a little fast and loose with that. I think, and I haven't looked at exactly what you read from the trial court's order, but my read of all of that is that the trial court found that your client through counsel had an opportunity, certainly, to participate, was on notice, and was doing things like, on behalf of the company, like filing the deck action and dissolving the corporation, and logged into the system. So he's on constructive notice at minimum, and simply strategically declined, as I think that was the last part of what you read. And so what's wrong with that is my question.
I mean, what's wrong with it is that's not what the statute says.
Well, the statute,
says
I think this turns
participation.
on what does participation mean, right?
Well, I mean, the court is saying they didn't participate. So I don't think we have a issue here where the court is saying, oh, yes, they did participate, and we have a difference of opinion about what participate means under the statute. The court is clearly saying they didn't participate. And then even further, the arbitrator enters a default judgment for the very reason that they didn't participate. So I don't think under any
Well,
reading
I
of
think we're
682, you can say
playing a
they
game with active participation, active defense, et cetera. But, at what point do you get to just thumb your nose at notices that are delivered, received, and in at least the case of logging in, affirmatively obtained?
Well, I
and
think if
call
the
that not
statute
participating.
said, I mean, what you're doing is you are trying to read participate out of the statute and replace it with appear. If counsel made an appearance, then that's enough. But that's not what the statute says. The statute says that the party opposing the arbitration has to participate in it. And here, there is just no dispute in the record. The trial court found it, the arbitrator found it, there was no participation. And that's what the statute says. That's what is required.
And so if we accept your argument on that, then the question becomes, I think under the way you've framed your argument, whether the trial court made a finding that an arbitration agreement existed. Am I following your argument?
I think that's right. I mean, there are a lot of erroneous statements in the trial court's order. I mean, the court says, at the very beginning that MHC was required to participate in the arbitration.
Let's focus on just sort of following the bouncing ball, because you've got a complicated background here and a pretty involved legal analysis. And I believe that you argued, and if you didn't tell me now, that the trial court did not make a finding that an arbitration agreement existed, right?
Correct.
Okay. Did you argue in the trial court that he was required to make that finding? Or did you move for rehearing or otherwise bring to his attention that you believe that to be a deficiency in the order?
Yes.
Where?
In the motion to vacate.
That was before the trial court ruled.
So what are you saying?
I'm talking about you're criticizing Judge Huey's rulings, and I'm that he didn't make this finding. And I'm asking at what point and where did you raise with Judge Huey whether the failure to make the finding or the finding that he made on the existence of an arbitration agreement was incorrect?
So are you asking if we went back and moved for rehearing on that?
Or in the hearing on the motion to vacate, did you tell him when he said he announced his ruling and then he entered an order?
No, he didn't. He did not announce his ruling.
Okay. He said, I'm going to take this under advisement. Then he issues his order. Did you move for rehearing?
We did not.
Okay.
But we raised the issue in the motion to vacate. We made the argument to him that it was his obligation to, in the first instance, decide whether the parties had formed an agreement.
Okay, but look, you're an experienced appellate lawyer. You know how this works. If he makes a big, long, detailed order and it is deficient with respect to findings or it contains incorrect findings, what do you have to do to preserve it?
So not on this, because we have preserved the issue, and it is not something that appeared for the first time. There is no requirement that he make particularized findings like there is with respect to the injunction, and so no motion for rehearing was required. So, in fact, we did argue in the trial court that the duty rested exclusively with the trial court to determine whether the parties had entered into an agreement. And the court didn't do it. And in fact,
Ms. Blank, I don't want to interrupt you, but I tried to tell you that you had 5.5 minutes left. If you want to say 5 minutes for rebuttal, you've got to.
I think I'll encroach a little bit if that's okay.
That's totally fine. It's your time.
You. But even if Physician Partners is correct that the court did make the determination, made it too late. The requirement is that it's a threshold determination before the arbitration commences. Here, the trial court, to the extent what it did in its order is characterized as a determination on the merits that the parties did enter into an agreement, that came woefully late, well after the arbitrator had already entered a default judgment against MHC, and after Physician Partners had moved to compel arbitration in the Volusia County action. So we knew this issue was pending all the way back to May 3rd, when Mr. Kohler sent a letter saying.
Just out of curiosity, when did the Volusia County action get served on Physician Partners?
It was July 21st.
So right around the time you filed, right around the time after the second award was issued, long after
The same day,
the second award. But
yes, the default.
so
judgment.
the complaint didn't get served on Physician Partners anytime near when the arbitration was happening, but he
Well,
had
the
filed.
problem is, the problem is kind of interesting is that, the complaint was filed, the arbitration demand was filed on May 12th. The declaratory judgment action complaint was filed on May 18th. And the arbitration hearing happened on the 23rd. Wasn't a lot of time. And,
No, but he certainly could have provided a courtesy copy to the arbitrator and said, I want to have a stay, or at least notified Physician Partners. You're in a dynamic environment. He was a busy guy that week.
Well, Physician Partners well understood that there was an issue about the existence of the contract, because Kohler sent them a letter on May 3rd saying.
Is that in our
"We're not
record?
bound." I'm sorry?
Where's that letter in our record?
It is App 358. So he sends the letter and he says, I'll just read it to you. MHC Holdings maintains no physician affiliate agreement with Physician Partners. The purported assignment document that you have provided to me, it describes it, but it says Dr. Watry had passed prior to the execution of that assignment. So the issues are already raised on May 3rd, even before Physician Partners files its demand for arbitration. So it well knew that what it should have done is filed a motion to compel arbitration.
Well,
instead of
and you can
pushing
put
it.
you can put that shoe right on the other foot. Your
But
guy well knew.
I'm saying fair's fair on that. If you're going to say that it was incumbent upon MHC to take action, Physician Partners well knew that this dispute was pending as well. And it, of course, the burden is on it to establish that there was an agreement to arbitrate rather than just press forward when it knew that the trial court had the threshold obligation to make the determination. So I think I've got a minute and a half, which I would like to reserve for rebuttal.
I'll reserve it for you.
Thank
I'll
you.
give you 2 minutes. How's that?
Perfect. Thanks. Thanks.
Ms. Evans?
Good morning, and may it please the court. My name is Diana Evans, and I represent the Appleby Physician Partners. In this appeal, MHC has crafted a labyrinth of legal arguments built upon a foundation of misdirection and omission. But this court doesn't need to enter the labyrinth. Instead, if it uses the Florida Arbitration Code as its guide and addresses the questions that have been properly raised before this court and not waived, the path to resolution is clear. Keeping in line with this court's obligation to preserve the finality of arbitration proceedings and to protect the integrity of the arbitration process, this court should affirm the trial court's order, confirming both the liability award and the injunction award for three main reasons. The first is that as a procedural matter, MHC has doubly waived its right to challenge whether there's an agreement to arbitrate between itself and Physician Partners. And this issue is dispositive as to this court's resolution on the liability award. The second reason is that contrary to MHC's assertion, the trial court did make a ruling that an agreement to arbitrate existed between MHC and Physician Partners. And third, specifically as it relates to the injunction award, MHC has failed to raise any cognizable basis under the Florida Arbitration Code that would warrant vacating that award. Before I turn to my first point, I'd first like to orient this court as to the scope of review because MHC has failed to do so. Review of arbitration awards in Florida is very limited. And in fact, some courts have noted that it is the narrowest scope of review in all of American jurisprudence. The only grounds on which an award can be vacated are outlined in the Florida Arbitration Code. And as it relates to this case, those are specifically contained in section 682.13, subsection 1, and 682.081, subsection 2b, specifically as it relates to the injunction award. Errors of judgment as to the law or facts that might have been made by the arbitrator are not sufficient grounds to vacate an award. And so with that in mind, I'm going to turn to my first point, which the MHC has doubly waived its right to challenge whether the court's confirmation on the basis that there was no agreement to arbitrate between the parties. As discussed today, MHC's main argument in this appeal is that the trial court erred because it failed to determine a threshold issue whether an agreement to arbitrate existed between the parties. But this court doesn't need to answer that question because MHC waived the right to bring that issue before this court. As Judge LaBritte noted, under section 682.13, subsection 1e, an arbitral award may be vacated if there was no agreement to arbitrate unless the person participated in the arbitration proceeding without raising the objection. Because the trial court found in its order, pages 547 through 548 of the record, that MHC participated in the arbitration proceeding through the appearance of its general counsel, Charles Kohler, the trial court found that MHC waived its right to challenge whether an agreement to arbitrate existed between the parties. That's MHC's first waiver. But MHC has also waived that issue before this court because MHC did not challenge the court's ruling in that regard in its initial brief. In fact, the word waive or waiver appears one time in MHC's initial brief, and that's on page 27. In their reply brief, MHC tries to say that they did address it, and they point to one sentence contained in the initial brief that states that MHC's failure to appear in the arbitration proceeding did not and could not waive MHC's objection to the arbitration. There's a little bit more to that sentence, but basically that's it. That's all MHC raises. That is not sufficient to preserve that issue before this court. The trial court didn't find that it was MHC's quote unquote failure to appear that waived its ability to challenge the agreement to arbitrate. Rather, the trial court found specifically that it was MHC's participation that waived their ability to arbitrate. And now I know that Judge LaBritte spoke with Ms. Blank today about what it means to participate. But again, that issue was not raised in the initial brief. It honestly wasn't even raised in their reply brief. And so MHC cannot sit here today and challenge whether the trial court correctly found that it participated in the arbitration. That finding is entitled to deference by this court, and therefore this court should find that MHC has waived that issue on this appeal and should find that the liability award was properly confirmed by the trial court. Now, to briefly address the final point that was made by Ms. Blank today, that this is a threshold issue that can never be waived, essentially, and that it always has to be brought first. That interpretation would essentially render a portion of section 682.13, subsection 1e, superfluous. Again, the statute specifically contemplates that this is an issue that can be waived if it's not raised. If the court were to adopt MHC's assertion that this always had to be raised first, that portion of the statute that contemplates a waiver would be completely read out of the statute. And that simply cannot be the conclusion that this court reaches today. Also, district courts around the state of Florida who have addressed this issue of whether certain issues in arbitration are waivable have found that they are. For example, in the City of Miami case versus the Fraternal Order of Police Lodge, that's 248 Southern 3rd 273 from the Florida 3rd DCA in 2018, found that unlike the court's subject matter jurisdiction, which cannot be conferred by the parties, an arbitrator's jurisdiction derives from the parties' agreement, and that goes beyond contractual agreements, also agreements before the arbitrator, can broaden during the course of the arbitration by waiver, failure to object, and consent. The fifth DCA in the Avatar Properties case also found similarly that an arbitrator's quote unquote jurisdiction can be waived. And for that reason, this court doesn't even need to reach the question of whether the arbitrator or the trial court should have determined whether an agreement to arbitrate exists between the parties. That issue has been waived. That takes me to the second issue, which is that even if MHC had not waived the right to challenge the existence of an agreement between MHC and physician partners, it doesn't matter because the trial court did address this issue and did find that an agreement to arbitrate existed between the parties. There are at least 7 times in the trial court's order where it makes reference to findings that reveal that it did consider this issue and found in favor of physician partners. I'll give the court 2 clear examples. On page 542 of the record, the trial court states, MHC unequivocally, willingly, and knowingly, for consideration, assumed all rights, duties, and obligations under the contract, including the arbitration provision and the right of first refusal. And that's contained in the background section of the court's order. Later in the order, the court goes on to state that because MHC signed the contract twice, it is a party. Therefore, the trial court did address the issue of whether or not an agreement to arbitrate existed between the parties and found that such an agreement existed. MHC then jumps into arguing whether, as a matter of substance, a contract existed between the parties. But MHC can't both argue that the trial court failed to make that finding and then also try to argue the merits of whether a contract existed between the parties. So to the extent that MHC dives into the substance of whether a contract existed between the parties, that issue has also been waived because MHC did not properly preserve it before this court. And now finally, as to the third issue, I'd just like to touch briefly upon the injunction award and some of the arguments that MHC has raised there. I know those haven't been raised before the court today, so I'll keep it brief. Specifically, again, we need to look at the Florida Arbitration Code and what it provides as far as what can be grounds for vacating an injunction award rendered in an arbitration. And for that, we look at section 682.081, subsection 2B. And there, the statute provides that the court shall vacate a provisional revenue award for injunctive or equitable relief, which fails to satisfy the legal standards for awarding a party injunctive or equitable relief. Like all of its other arguments, MHC does not frame any of the infirmities it raises with respect to the injunction award within the lens of the Florida Arbitration Code. MHC vaguely makes about 8 arguments with respect to the injunction award, but I'm going to touch on the one that could potentially fall within what this court can review under the Florida Arbitration Code. And that's related to whether or not the injunction was invalid because the arbitrator's order failed to satisfy the requirements of Florida common law for issuing an injunction, including whether there's a substantial likelihood of success on the merits. According to MHC, Florida common law should have applied to this analysis. So, for example, whether there's a substantial likelihood of success on the merits, whether there's been a showing of irreparable harm, whether there's an adequate remedy at law, and whether the public policy favors the issuance of an injunction. But again, MHC misdirects the court. The question is, what does Florida common law tell the arbitrator to do? In this instance, the question was, what do the ALA rules tell the arbitrator to do? Because the parties agreed, pursuant to section 6 of their contract, which is on page 309 of the record, that the standard for awarding injunctive relief would be governed by the ALA rules, which was incorporated by the parties into their contracts. And under the ALA rules, in determining whether to award emergency relief, the arbitrator should determine whether the claimant is likely to succeed on the merits and will suffer irreparable harm without emergency relief. There's also the fact that the arbitrator has to consider the balance of the harms. And that's exactly what the arbitrator did in this case. He looked at whether physician partners was likely to succeed on the merits and whether it would suffer irreparable harm. And he found that it would, and therefore entered injunctive relief in favor of physician partners. The court can't point blank accept MHC's point that the arbitrator was required to apply the Florida common law standard, especially where the parties' contract called for the application of a completely different standard, which the arbitrator did apply. Because MHC has failed to raise a single basis within the Florida Arbitration Code, demonstrating that the trial court erred in confirming both the liability award and the injunction award, this court should affirm the trial court's order confirming both awards. And if the panel has no further questions, I will cede the rest of my time to the court. Thank you.
Thank you. Just a few points. The court has expressed some concern that MHC participated in the arbitration based on the AHLA's rules for registering on the website and the docket. But keep in mind, the AHLA rules do not apply to MHC until the court determines that there's an agreement to arbitrate that includes those rules. And that had not happened. Similarly, unless and until the court determined that the AHLA rules govern the injunction.
I'm sorry, there goes your argument on the trial court not finding, because he necessarily had to find that to find the existence of an agreement to arbitrate.
In fact, he didn't. That's the whole point.
Well, but he found them bound by the ALA rules, which were incorporated. And so you kind of can't have it both ways on that, can you?
So if he purports, he did a lot of things that, are incorrect and are internally inconsistent in the order, including that this decision was both for the arbitrator and then, at least according to Physician Partners, proceeded to make that determination anyway, which I don't think he did. In fact, I think if you look carefully, what you'll see he did is he recites what the arbitrators found. So if you look at page 9 of the order, which is App 548, the court sets forth the arbitrator's findings, not its own. The court says, for example, the arbitration orders address this argument, as the arbitrator explained, and then went on to say, as the arbitrator concluded, as the arbitrator further found. So it's clear that these were not independent findings by the trial court, but merely a recitation of the findings that were made by the arbitrator. And so, notwithstanding the argument that the trial court actually made these determinations, in fact, it did not, and it abdicated.
Your position that the trial court couldn't adopt the findings that he cherry picked out of the arbitrator's order?
I think it was required
like you would with a magistrate's report or something?
No, because it was incumbent upon the court to make the predicate determination about whether there was an agreement. He couldn't say, okay, I'm doing that after the fact because, there's already been an arbitration and the arbitrator has already ruled on the merits against.
Ms. Blank, your time has expired, but I'll let you finish your answer if you feel you didn't finish it.
Okay.
Did you finish the answer?
I just wanted to say one more thing in response to it. So because the trial court adopted the arbitrator's conclusions and the trial court could not do that, it was required to make the predicate threshold determination. It's quite clear that the court should reverse that determination if in fact it believes that the trial court actually made it.
All right, ladies.